My lords, I was on ground 2. I'd addressed the law, and I'm most of the way, or 2/3 of the way, 3/5 of the way through, addressing the grounds of principle. I've made 3 points, and I was coming on to the 4th point, which concerns the Sale of Goods Act itself. And it's the point that we make at paragraph 54.5 of our skeleton argument in the core bundle, tab 5, page 84. And it's that section 20A imposes requirements which exist as between a seller and a buyer. It does not seek to impose requirements which exist as between an insured and his insurer. And we say there's no reason why the common law should follow suit. And so to expand on this, section 20A was introduced to address a problem that had arisen where a buyer bought a specified quantity of goods forming part of a bulk, but the seller became insolvent before the goods were ascertained. And in such a case, and by virtue of section 16A of the Sale of Goods, 16 of the Sale of Goods Act, both the price and the goods might pass to an office holder in insolvency for the benefit of the seller's secured creditors generally, rather than to the buyer. And the Law Commission consulted members of the commodity and other trade associations dealing in bulk produce such as grains, animal feedstuff and vegetable oils. And extracts from the Law Commission's report are, as the court is aware, in the authorities bundle at tab 22. And of importance are the final 2 sentences of paragraph 1.3 in tab 22.
Tab 22.
Yeah, and it's the bottom of page 523 going over to the top of page 524. The final 2 sentences of paragraph 1.3, starting right at the bottom of page 523, some respondents, but fewer than 10%, had had experience of not receiving goods out of bulk because the seller had gone into liquidation after they had paid but before delivery. Almost all the respondents who purchased quantities of goods out of bulk insured the goods against loss or damage. None reported any difficulty in obtaining insurance in respect of goods forming part of a larger bulk. And then at paragraph 212 on page 527, it is said that although section 16 prevents property in goods forming part of a bulk from passing before ascertainment, it does not prevent risk from passing and does not prevent the purchaser of a quantity forming part of a bulk from acquiring an insurable interest in the goods.
Sorry, where are you? I missed the
2.12.
Sorry, paragraph 2.12 at the bottom of page 527. And the point that they're making is that even though property doesn't pass, that does not prevent risk from passing and does not prevent the purchaser of a quantity forming part of a bulk from acquiring an insurable interest in the goods before ascertainment. And the authority cited as English and Stock. It is also said that it is common enough for the risk of loss of or damage to the goods to pass to the buyer before the property passes, and a buyer of goods out of the bulk who is prevented by section 16 from acquiring property in the goods may still have to bear the loss if the goods are lost or damaged, and should therefore, even under the present law, that's the law in 1993, consider insurance. And there's one other passage, which is on the previous page 526, and it's in footnote 24. Towards the end of footnote 24, there is the sentence, the idea that the buyer can acquire an undivided share in the whole bulk has not, however, been completely rejected by English law. It has been accepted in relation to the passing of risk and the acquisition of an insurable interest. And again, there's a reference to English and Stock and other cases.
Do Stearns and Vickers of any relevance for present purposes?
I'm not aware that it is.
No.
Okay. So what we say is it's clear, therefore, that in 1993, the rights of a buyer of bulk commodities vis-à-vis his seller lagged behind the rights of such a buyer vis-à-vis his insurer. None had difficulty in insuring against the risk of loss of goods forming part of a bulk, and it was widely accepted that such buyers had a sufficient interest in such goods to insure them. And as regards the subject matter of the insurance in this case, insurers agreed to insure goods stored in bulk in locations declared to them, and the location of the bulks were duly declared. There was no suggestion that there's anything unusual about this particular policy, but the effect of insurer's case on this appeal is to seek to deny an insurable interest in goods stored at the declared locations, and to require the insured to identify the storage location of the bulks more specifically in its purchase contracts than insurers required in the policy itself. That is, in such a way as would satisfy the requirements of Section 20A. And we say that makes no sense. Insurers considered the bulk to be sufficiently identified for the purposes of the policy and accepted the storage declarations and premium accordingly. The terms of the purchase contracts or any subsequent agreement between the insured and the buyer is not insurers' concern. The simple point is that having paid for the goods stored in a location declared to insurers, Quadra would benefit by the safety of those goods and be prejudiced by their loss, and thus have an insurable interest in them. And that must be the position, whether as in English and stock the risk had passed to the buyer, or whether as an Cumberland bone it had not. And that is essentially the point we make in our appeal skeleton at paragraph 54.6. And the fifth and final point we make is that is what I've made before. It's the restriction which insurers seek to impose on the circumstances in which an assured may have an insurable interest in goods is contrary to the direction in which the law is developing. And that's the point that I made earlier. So for all those reasons, we submit that insurers' second ground of appeal should fail. The restriction for which insurers contend is contrary to both authority and principle. But in any event, we say that the goods in this case were sufficiently identified for the purposes of Section 20A of the Sale of Goods Act, and accordingly that Quadra had an insurable interest in the grain that was physically present in the elevators by virtue of having acquired a proprietary interest in the bulks of which those goods formed part pursuant to Section 20A. And if Quadra is correct on this point, insurer's second ground of appeal will fall away entirely. As such, this additional ground for upholding the judge's decision is potentially determinative. Now, the court has already been taken to Section 20A of the Sale of Goods Act. Section 20A1, it's in the authorities bundle, tab 1, page 6. Section 20A applies to a contract for the sale of specified quantity of unascertained goods where two conditions are met. And we're concerned with the first of those conditions, whether the goods or some of them form part of a bulk which is identified either in the contract or by subsequent agreement between the parties. And the court's been taken to the definition of bulk, which is in section 61.1 in the authorities bundle, page 1, page 7. Bulk means a mass or collection of goods of the same kind which is contained in a defined space or area, and such that any goods in the bulk are interchangeable with any other goods therein, that's in the bulk, of the same number or quantity. And the key question here is whether each of the Zaplaski, Bilgerod and Ismail elevators constituted a defined space or area for these purposes. Now, the Law Commission report offers some guidance in this regard. That is, again, the authorities bundle, tab 22.259. Sorry, is that right? Can't be right. Must be 529. Yes, 529. At paragraph 4.3, which contains some examples of bulks that would qualify. They include, at subparagraph B, a mass of barley in an identified silo, and at C, oil in an identified storage tank, and at E, ingots of gold in an identified vault. All those places, the identified silo, the identified storage tank, the identified vault, are defined spaces. But a defined space may be more general. For example, at A bulk would include a cargo of wheat in a named ship, as distinct from a named hold on board that ship. And Stock in Inglis was such a case. 2 parcels of unsegregated sugar were said to be carried on board the City of Dublin without any more precision as to precisely where on board the ship they were located. The City of Dublin was a defined space. But at paragraph 4.3g of the Law Commission report, the example is also given of a heap of coal in the open at a specified location. This is different from the previous examples, since the space is not confined. The coal is stored in the open at a specified location, and that is probably stored in a defined area as opposed to a defined space. Now, the width of the term defined space or area is addressed by Professor Bridge in his book on the sale of goods, which is in the authorities bundle at tab 21.
Yeah.
And at page 512 it starts. But the relevant passage appears on page 520 in the bundle. And it's about a third of the way down page 520. Starting, a further point relates to what constitutes a defined space or area.
Sorry.
It's after footnote 251, if that helps.
Oh yeah, got it.
A further point relates to what constitutes a defined space or area. A pragmatic interpretation of this phrase would confine its operation to cases where the size of the bulk can be computed by practical means. Then he goes on, a defined space will usually and without undue difficulty be referable to a named warehouse, and I add, as opposed to a named silo in a warehouse, or ship, and I add, as opposed to a named hold on that ship. But a defined area could be large enough for a real difficulty to arise in applying Section 20A. A seller may state that it's holding goods for the buyer on its premises without stating precisely where, though both parties may know that the seller has only one, albeit extensive site. This is not quite a case of the seller's general trading stock, and a site ought therefore to be a defined area. Now, at paragraph 111 of the judgment, the judge below rightly accepted that there may be cases in which a site, and even an extensive one, will constitute a defined area. He also rightly accepted that there may be cases where the parties agree.
Sorry, you're going too far. Give it too fast.
I'm so sorry. Paragraph 111 of the judgment in the core bundle, tab 8, page 138. In paragraph 111, Mr. Justice Butcher, we say rightly, accepted that there may be cases in which a site, and even an extensive one, will constitute a defined area. And we say he rightly accepted that there may be cases where the parties agree that the bulk is all the goods of a certain type within that area. He just did not accept that this was such a case. And he found instructive the case of RGB Resources, the decision of the High Court of Singapore.
Yeah. And
the court has seen that case. It's in the authorities bundle at tab 12. The court would call it, it's concerned a claim by a bank to various metals stored in warehouses in Singapore, and the claim related to different groups of metals comprising nickel, copper, and tin. And those metals had been stored in 2 different warehouses operated by Fujitrans in Singapore. And each contract of sale to the bank was for a specific quantity of unascertained metals. And the question arose whether the bank had nonetheless acquired a proprietary interest under the Singaporean equivalent of Section 20A. And the Singapore High Court concluded that it had not. And the judge below rightly observed, when considering this case, which is at paragraph 108 of his judgment, Core Bundle 8, page 138, the fact to which the Singapore court attached importance was the fact that the warehouse receipts did not identify the location of the particular warehouse in which the relevant metals were held. And this was a reference to the lack of distinction between the 2 different warehouses operated by Fujitrans. And we can see that in the judgment itself in RGB at paragraph 68 on page 238. The warehouse receipts did not identify the location of the particular warehouse in which the metals were stored each warehouse receipt was on the letterhead of Fuji Trans, and there was a reference in its contents only to in warehouse Singapore. And the contents of the warehouse receipts are themselves set out at paragraph 28 of the judgment at page 230. At paragraph 28 of 230, it quotes the warehouse receipts as saying, "We hereby certify that we are holding the AM cargo for your account as per details given below in terms of in warehouse Singapore to the order of credit Lyonnaise," and so on. Now, the facts of the present case are materially different from those in RGB Resources. We've looked at the first Zaplasky warehouse receipt, for example. That was in the supplementary bundle, tab 19. And we saw that it was on the Zaplasky letterhead and the address was given. And the address was repeated in the body of the warehouse receipt. But in this case, the important point is there is only one Zaplasky elevator, as compared to the position in RGB Resources, where there were two different warehouses. So unlike RGB Resources, there is no uncertainty as to the location of the elevator in which the grain, in this case, is stored.
Sorry, use of the expression elevator again.
Yes.
You're using that to obscure the not deliberately I'm suggesting, but
No, the site or complex.
Yes, I mean the elevator is the company.
Yes.
It has a site or complex on which we know there are a number of warehouses. I think we saw the plural used in the
That's correct.
receipt itself. So where do you draw the distinction, the line? I mean, what's the difference between RBG Resources saying it's in warehouse Singapore and there were two warehouses on different sites, and a situation where you've got one site but two warehouses? Where's the distinction?
Well, I say there is a distinction between saying your goods are either on that site, site A, or that site, site B. You don't know where your goods are. You don't know the precise location. There is uncertainty as to whether they're over there in site A or over there in site B.
I wouldn't know which warehouse they were in the complex in this case. They could be in warehouse 1 or warehouse 2.
Warehouse
or
one.
indeed both, in fact,
Yes.
depending on how much grain was actually stored for me, because the silos I think we've seen.
That's entirely right. But we say it's sufficient, and where we draw the line is saying the sufficient precision is knowing that they are at the one site, albeit you don't know whether they're in building 1 or building 2, or silo 1 or silo 2.
So the facility is the defined area,
Yes.
and it matters not that within the facility there are a number of silos or a number of warehouses. They may be a defined space, but they're not a defined area. That's the point.
But conversely, Singapore couldn't count as a defined area.
It couldn't, because there's two different areas.
Well, it's an area, Singapore.
Oh, the whole of Singapore can't. But again, Bordeaux, the examples are given, certainly in Bridge, I think. Bordeaux doesn't count as a defined area. That's too broad. That's a geographical area.
Right.
That's not.
What is the principal distinction between them? Is it that the identification in, you say, our case, means that you can go to the named address and you can easily physically find the cargo there?
Yes.
Whereas if it's as broad as Singapore, you simply wouldn't be able to identify it in practical terms. Is that?
It is, and again,
It's the ability physically to find it. Is that the right distinction?
Yes, I think the practical terms reflects what Professor Bridge was talking about when he looks at what's the practicalities here, and that is it. In our case, you can turn up at the elevator, meaning the company's site. There was only one site. Bastico presented themselves at that address, and they were then taken to the goods, as opposed to landing at Singapore Airport, and then what? And then saying, my goods are here somewhere. That is the practical distinction, that if you present yourself at the address of the, at the complex, as Bastico did, then they were shown where within that complex the goods were, and they were measurable within that complex. as opposed to a geographical area where you don't know where in Bordeaux or where in Singapore your goods might lie.
To what extent does this test also depend upon whether it's necessary, as the Law Commission appeared to indicate, to distinguish a bulk from the general stock of a seller?
Yes, so it is important, and what that distinction is driving at is where you buy goods from a seller, and a seller simply says, I will sell you something I produce. I will sell you, I mean, there's been a number of examples, I was trying to avoid them, but I will sell you a BMW car 5 Series. Not any particular one in any particular location, but one that will be made. That is not good enough to provide the precision necessary for the purpose of this act. A car made by BMW at some point in time is general stock. What we're looking at here is not in the same category. The vendor is agri-finance, who has stock in situ at the elevator, meaning the warehousing company, which is sold under the sale contract in situ to Quadra. And that is not the vendor, agri-finance's general stock that they might acquire from farmers and so on. It is stock that they have in situ in the site that we're concerned. So it's not some goods that may in the future become identified. There are goods that are identified already in situ in the warehouse. The bulk is identifiable in the warehouse as at the date of issue of the warehouse receipts.
Is it, to use another example, it's a vendor, a seller who has goods of the same description in 2 different locations, and it would be sufficient to identify which of the 2 locations the relevant bulk is to be found in?
Yes. It would be sufficient to identify which of the 2 locations the relevant bulk is to be found in, because that gives you the sufficient certainty to know where the goods are, where the bulk is located.
And in a sense, provided you distinguish it from the other location on those facts, it doesn't matter how detailed a specification you give of where the particular goods are to be found on site. That's irrelevant, in the same way as it was irrelevant, if you like, which hold of the ship
Yes.
in English and stock the
Yes.
sugar was to be found, provided you know that that's the ship on which the sugar is to be found.
Yes. And similarly, I think on insurer's case in relation to Cumberland Bone, where precisely within the Atlantic Oil Company's works, the relevant fish scrap was to be found. It's sufficient to identify the works, as I understand it, on their case.
Well, it wouldn't have been sufficient to pass title as a matter of sale of goods, I don't think, was it?
Not as at the date.
Not in Cumberland Bone.
No, not as the date it was. But if you were looking at the facts of Cumberland Bone in the context of Section 20A, as I understand insurer's submissions, that the bulk may have been sufficiently identified for the purposes of the equivalent of Section 20A, because there was a reference to Atlantic Oil's company's works. And if that's right, and we say it is, then that applies equally in this case, because you've identified the site, even if you haven't identified the particular silo.
Well, the trouble in that case, though, is that... Sorry, yeah, okay, no, I understand, yeah.
And would it extend to a case where you did have 2 quite separate sites, but what was identified was that it was going to come from one or other of them, each being identified? I buy 5,000 tonnes of wheat. The seller says I've got 2 warehouses, one in Immingham and one in Tilbury, and they've got 10,000 in, but I haven't yet decided which of the 2 warehouses it's going to come out of. It'll come out of one of those 2. Would that be sufficient?
I don't think that would, because I think there you do have a bulk on one site and a bulk on another site, distinct bulks, and you don't know whether, if you're looking to inspect your goods, for example, the goods being held to your order, you wouldn't know whether to go to one location or the other. That's different from where you have a location, a ship, which happens to be split into 7 holes, for example. So what insurers, the point insurers raise, which is paragraph 82 of their skeleton argument,
Just before you get,
Oh,
before
sorry.
we go there, so
do apologise.
is Mr. Justice Butcher right in paragraph 111, or is he wrong? You sort of, I think, I got the impression you didn't actually really agree with him, but you didn't actually say so.
He's wrong in his conclusion. So he's right that there may be cases in which a site, and even extensive one, may constitute a defined area. He's correct there. And he's correct that there may be cases where the parties agree that the bulk is all the goods of a certain type within that area. He's correct about that. Where we depart from him is his conclusion in relation on the facts of this case. He says, it does not appear to me, however, that it can be said that in the present case that there was an agreement which identified the bulk as all the goods of the relevant type in the elevator with a capital E as a whole. And he says there was no reference to the bulks in the warehouse receipts. Now, the point we make is that the identification of the goods in the warehouse receipts in the form it was is sufficient to identify the bulk, that is all the undivided corn within the site, the complex, as being the bulk in question.
I think where he says elevator capital E, we must take him, I think, to mean facility.
Yes. So we agree with the judge in terms of his analysis of how the width or the breadth rather of what a defined site or area may be. Where we disagree with him, in part from his decision, is that in this case, on the facts of this case, the site was sufficient. And this is really the point insurers make, and with which the judge agreed. The insurers make that there are numerous buildings on the site as a Plasky elevator, and there's no identification of the particular building or the silo in which the grain is stored, or the particular buildings or silo where all the grain of the particular type referred to in the warehouse receipt is stored. That's the point the judge agreed with, and we say he was wrong in that limited respect. A statement that 5,000 metric tons of corn is being held at the address of the company's Zablaski elevator at that site is no different to a statement that 5,000 metric tons of wheat or corn, should be corn, is stored on board a named ship. That is the example given by the Law Commission as constituting an identified bulk, and that was the case in English and Stock. There was no suggestion in the Law Commission report or in English and Stock that the contract or bill of lading must identify the particular hold in which the goods were shipped. And we say that's unsurprising. It is not uncommon, at least, in international commodity sales for a seller to identify the buyer's goods by issuing a bill of lading identifying the weight of the goods shipped on a named ship. And insurers accept that the goods in English and Stock were sufficiently identified, and yet they suggest that in order for an undivided share in bulks at the sites in this case to pass to Quadra, reference must have been made to the particular silos in which the bulks were located. And we say that simply cannot be right. The bulk in such a case comprises all the goods of the same kind which are stored on the site from time to time.
Does it matter then? I mean, if you're right that the site is the defined area, what's the position if, for example, corn of the relevant description is stored in 6 separate silos and not just in one silo?
Within the one complex?
Within the one defined area.
Yeah, so the silos may be a defined space. The complex itself may be the defined area.
So you would say it's still one bulk, is that right?
It's still one bulk.
Even though it's actually, I mean, physically, it's not one mass like the heap of coal. It's actually, if it's in 5 silos, it's actually 5 separate masses.
But again, in terms of practically speaking,
You say the same point as to say if the corn were in the hold of a ship or wheat.
exactly. If I presented the bill of lading in English and Stock, I would have got some sugar off the ship rather than from a particular hold of the ship. If I would have gone to the Zablaski warehouse with a warehouse receipt before the fraud and asked for 5,000 metric tons of corn, I'd have been given 5,000 metric tons of corn. Whether it's drawn from silo 1 or silo 2 wouldn't really matter. I'd get it from the Zablaski warehouse when I presented my warehouse certificate to them.
Because they reserve the right in their terms and conditions to do precisely that.
Precisely.
I'm struggling with the last bit of paragraph 111. Which seems to focus on what Agrifinance might or might not have agreed. But Agrifinance presumably knew the terms on which the Zablinski elevator operated. I mean, otherwise, why is it entrusting its goods to it?
Well, it's even closer than that because it's part of the same group as the elevator.
Okay,
The-
so
sorry, go on.
I think
The judge's point, which I'm not quite sure what your answer is that if the warehouse receipt is to be the document which identifies the bulk sufficiently, and you therefore have to interpret the warehouse receipt as meaning all goods on this site of the relevant type. That isn't what these warehouse receipts would have meant, because there was an ability within that particular site to have segregated parcels which were specifically identified for a particular customer and therefore wouldn't be part of that bulk.
Yes.
That's the judge's point. What's the answer to that?
I think, we say it misses the mark. So as my lord says it, the judge's point is if segregated storage might occur, then the seller would not have agreed that all the goods of a particular type within the elevator formed the relevant bulk in respect of which Quadra might become an owner in common. And he points to a storage contract, it was a Kernel storage contract, was not concerned with grains like corn, wheat or barley. It happened to be concerned with sunflower seeds, but so be it. We say the act of segregation is an act of ascertainment within the meaning of section 16. And segregated grain, therefore, will not form part of an undivided bulk. There is, in other words, no question of any segregated grain forming part of the bulk to which Quadra would be an owner in common. Property in the segregated grain might well rest with the buyer who requested the segregation.
That I follow, but how then do you interpret, if that were the situation, how could you then interpret the warehouse receipt as extending to all the grain of that particular type on the site? It could
All the undivided grain on the particular site, or the commingled grain on the particular site.
How would you know that if you went to inspect?
Again, this was the point that when I pointed to Form 36 some time ago this morning, but the Form 36 which we looked at, which was issued to the Bastico inspectors, recorded in the top right-hand corner, general storage. And so, as distinct from segregated storage. So that the site is going to know which is segregated. Necessarily, it must know. The site is going to know which is segregated and which isn't. And what the warehouse receipts is not saying you've got an interest in some goods that have been specifically segregated off. What you've got is an interest in the goods which are not segregated off, in common with the common practice on how these warehouses work. Goods will be commingled unless there is a specific agreement to segregation. Clause 2.3, for example, in the storage agreement. And so when the warehouse receipt refers to 5,000 tonnes, it's not referring to corn that's segregated, it's referring to the undivided bulk in the warehouse, the commingled bulk in the warehouse. And so looking at the warehouse receipts in the context in which the warehouses operated and all parties knew, what the warehouse receipt is saying is the bulk is the undivided bulk of the same goods in the warehouse, in silo 1, silo 2, wherever it happens to be stored. And so if you present the warehouse receipt to, for example, the Zablaski elevator, you're not going to be given some segregated corn. You're only going to be given corn that is part of an undivided bulk, wherever that bulk happens to be stored from time to time.
Yeah, because the segregated bulk in the example, the segregated grain in the example is not capable of being interchangeable with any other goods of the same number or quantity because it's been segregated.
That's
So
the point.
those are ascertained goods.
Yes.
So they fall outside the definition of bulk in section 61.
Yes. That's the point.
That's the point in practice, but you say that's, the warehouse receipt is doing its identifying purpose for section 20A simply by referring to everything, because that is to be interpreted as meaning everything in general storage, not or everything unascertained.
Yes. Just forgive me one moment. I just need to find the reference. Oh, Ennis, sorry. Yes. I'm being told to read out something. I just need to know what it is I should be reading out. The point I've got here, and I'm going to read it out, we say it makes no sense to suggest that when identifying the bulk for the purposes of section 20A, the parties must specifically identify and exclude all goods in the elevator or vessel which are owned outright by another party or which have been segregated for another party. The bills and lading, English and stock did not do that. They identified the sugar on board the vessel. They didn't rule out anything else.
It's a refinement to the same point, isn't it? That it can't make any difference if you take the example of the bags of fertilizer example, which they give in the Law Commission report. There's a undivided bulk of one type of fertilizer in a particular part of the storehouse or the warehouse.
Yeah.
The fact that they've got 5 other different types of fertilizer stored elsewhere within the same facility can't mean that section 20A doesn't apply.
Yes.
It doesn't have to be just goods of one description and nothing else.
Yes. I mean,
Otherwise, commercially, it's a nonsense.
precisely that point. So we're looking at, I mean, you can analyse it in different ways, but it comes down to essentially that. You're looking at an undivided bulk, for example, of corn, and whether you've got wheat or barley or some other goods, that can't affect what the undivided bulk is.
Mm.
And whether you've got corn which has been segregated for someone else, that can't form part of the undivided bulk. And so what we say in relation, specifically in relation to what the judge says, towards the end of paragraph 111, is effectively his analysis and the insurance case on his appeals say you can't have an undivided bulk if there's something which is not part of that undivided bulk. And we say that makes no sense at all. If it's been segregated, it's not part and cannot be part of that undivided bulk. So it is no answer to the case that we advance. So it's for those reasons we respectfully submit that the judge was wrong on this limited aspect of the case. The bulk was sufficiently identified for the purpose of section 20A of the Sales of Goods Act in the warehouse receipts, is what we say. But of course, the warehouse receipts are not the contracts of sale. They were, however, part of a subsequent agreement between the seller, Agrifinance, and the buyer, Quadra. They were presented to us with an invoice requesting payment against them. You can see these findings in the judgment, paragraph 17 and 18. The judge recorded that in the performance of addendum 7, for example, of the Agrifinance contract, Agrifinance, the seller, presented the first Saplasky warehouse receipt to Quadra, and at paragraph 18, which is page 115 of the bundle, recorded that Agrifinance issued an invoice to Quadra asking for payment pursuant to addendum 7 against the presentation of the Saplasky warehouse receipt, and that Quadra paid. And the legal analysis of those facts is that the seller's presentation of the warehouse receipt was an offer to deliver goods in situ from the Saplasky site, identified therein, and for those goods to be held to Quadra's order, pending their further delivery to Quadra at the chosen port. And Quadra accepted that offer when it paid the price, so also assenting to the identification of the bulk of which those goods form part. And the bulk was thereby identified by subsequent agreement between Quadra, the buyer, and Agrifinance as the seller.
Sorry, just to interrupt, can I just go back
Yes.
to this paragraph 111, which still, I'm afraid, does puzzle me the end of this. If I understand the judge correctly, what he's saying is, it is possible for the trader to agree with the storage company that there might be segregated storage of its products.
Yes.
It's possible.
Yes.
You might have to pay for it. In fact, on the face of it, you probably would.
You probably would, because you use up more space than.
Well, somebody has to go around sticking labels on tanks and measuring out yours. You can't just be regarded as part of the bulk. So he said, if such segregated storage might occur, Agri-Finance would not have agreed that all the goods of a particular type within the whole facility form the relevant bulk in respect of which Quadra might become an owner in common. Why not? I mean, if you can find some people to buy from you from bulk,
Yes.
which means you don't have to pay the storage facility for the extra services of segregation, why wouldn't you? I mean, it's cheaper and easier for you as seller, isn't it?
It's
And-
illogical.
And if indeed you can get Quadra to agree with the storage facility, which it did,
Yes.
that it could just be delivered from bulk,
Yes.
everybody's happy.
Yes.
So why, I don't understand the commercial logic behind the judge's back end of 111 as to why Agri-Finance wouldn't have done it.
Well, nor do we, my lord. I mean, we the segregation.
No, you just didn't go on to say he was wrong there as well. You sort of stopped halfway through the
Well,
paragraph when I asked you.
Oh no, I'm sorry. I didn't mean to. We say there is no reason at all why all parties involved would not have agreed to identify the bulk concerned as the undivided, whatever it is, grain in the warehouse. The fact that there might be segregation doesn't undermine that conclusion. Segregation is an exception, and there may be all sorts of reasons why a particular trader, seller would want to segregate their cargo. But
And the judge's point is simply that isn't what the warehouse receipt does. The warehouse receipt, in fact, it is only to be interpreted as everything in the warehouse of the contract type. You say he's wrong about that. It's to be interpreted as everything other than that which is segregated. But I think that's the point.
Yes.
And if the judge were right about that as a matter of interpretation of the warehouse receipt, I can see, speaking for myself, the force of the point.
But if he's not, then
But if he's not, then doesn't.
then it doesn't provide a reason.
yes.
And as it happens, there was nothing in the insurance policy which required segregation of the goods.
No, quite the
In fact,
contrary.
quite the reverse. There is a clause that allows commixture of goods.
That, but it would also recognise that it covers all interests, including interests in bulk, wherever in the world they happen to be stored. So the policy has got wide terms, which will cover storage of goods in bulk, including specifically grains in Ukraine.
Right. So it comes back to the point my lord's just mentioned. In reality, it does come back if this paragraph is to be subjected to scrutiny. It comes back to this question about what does the warehouse receipt actually signify. Yes,
it does. And our essential submission in relation to that is you've got to construe the warehouse receipt in the context of what these parties would have understood, in the context of how the warehouses operate. In the sense that we are talking about commingled goods, goods which are undivided. There is an undivided bulk. And so when you're construing the warehouse receipt, that's the context in which you'll construe it. So I hope our submissions are clear in that regard, and also that we rely upon a subsequent agreement by reference to the presentation of the warehouse receipts and a request for payment, and by Quadra's paying of 80% of the purchase price against the presentation of those warehouse receipts as the agreement, the relevant agreement. And just to make a quick point, insurers suggest that agreement was not pleaded. And we say that's just wrong. It is pleaded. It's pleaded in paragraph 8.0 of the amended reply. No need to turn it up. I'll just give the reference. Core Bundle 16, page 248. So just to wrap this point up, the important point as regards our additional argument on ground 2 is that the bulks were sufficiently identified by agreement so as to confer an insurable interest on Quadra. But we say there is a further point, which is relevant only insofar, which I need to deal with, which is relevant only insofar as a separate question of whether Quadra in fact acquired a proprietary interest in the Zaplasky and Bilgerod cargoes. And let me just make that clear. Just common ground that under the line puzzle contracts, focusing on the cargoes at Ismail warehouse, the Ismail site. Property passed on payment. There's no issue about any delay in passing of property. But insurers maintain, and the judge agreed, this is paragraph 112 of his judgment, that by the express terms of the agri-finance contract, the parties agreed that Quadra would not acquire a title in an undivided share in the bulk when the conditions of section 20A1 were met, but only at a later time. And in our respectful submission, the judge was wrong in that limited regard as well. And you can just look at the relevant provisions. They're in the additional supplementary bundle, tab 12, at page 205. So tab 12 is what's been called as the agri-finance contract. It is the umbrella contract to which each of the addendums we've been considering, addendum 7, 8, 9, and 10, are addendums. The umbrella contract is at tab 12. And at page 205, yes. In the middle of the page, just above the bold which says price, it says title of ownership for the commodity is transferred from the seller to the buyer at the moment when the commodity is accepted at place of delivery. And the place of delivery, if we go back to page 203, we can see a heading in the middle of the page on the right-hand side, delivery terms and conditions. Delivery of goods is made by rail cars and or trucks. And then the delivery is DAT, delivery at terminal, sea trade port, Ukraine at buyer's option. So title is transferred at the sea trade port. But going back going on to page 204 in the middle of those two provisions, under the heading payment, is that here?
205.
205, I'm so sorry. Thank you. Under the heading payment, we have another reference to transferring of goods. Period of transferring of goods at internal warehouses from seller to buyer to be specified in the addendums. And the addendums specify a period at which that transferring inland is to happen. So those are the relevant provisions we're considering as to whether the time at which title under section 20A is transferred is delayed or deferred. Now what we say is none of these provisions expressly refers to section 20A of the Sale of Goods Act or to the acquisition of an undivided share in the bulk or anything similar. But at paragraphs 112 and 113 of the judgment, insurers argued and the judge agreed that the parties agreed to defer the application of section 20A until the arrival of the goods at the sea trade port. In other words, the judge concluded that the reference to the title of ownership for the commodity in the agri-finance contract is a reference to the property in the undivided share of the bulk, as opposed to the general property in the goods. The difficulty with that construction, we say, is that once a quantity of grain is segregated from the bulk for dispatch to Quadra at the seaport, that quantity is necessarily ascertained. And that is clear from both the consignment note and the register of railway wagons that we looked at tabs 41 and 57 of the supplementary bundle. In other words, by the time the commodity is transferred to the place of delivery, the seaport, section 20A would have no application at all. Quadra will have acquired property outright. So although argued as a deferral of the application of section 20A, the construction favoured by the judge means that Quadra never acquired title in an undivided share in the bulk of which the goods form part, notwithstanding all the parties knew upon entering the contract that the grain would be stored in bulk at the warehouses and that Quadra would be required to pay 80% of the purchase price for them. That, we say, is a surprising construction of the agri-finance contract, which gives no meaning to that last provision that we looked at, the transfer from seller to buyer at inland warehouses. The better and more natural construction is that the transfer from seller to buyer that was to take place at the internal warehouse was intended to be the transfer of property in an undivided share in the bulk, of which, as both parties knew, the goods form part. And at paragraph 88 of their skeleton argument, the point taken against us, insurers say that this cannot be right because the reference to a transfer from seller to buyer at inland warehouses appears under the payment clause and not under the delivery terms and conditions. But we say the location of it is not in the least surprising because it's an express requirement of section 20A that the buyer should pay the price for some of all of the goods which are the subject of the contract and which form part of the bulk. So we say the two-stage delivery involves a transfer of title to the undivided bulk, share in the undivided bulk at the inland warehouse, and transfer of title outright at delivery at terminal seaport. Otherwise, on the judge's construction and the argument that the insurers contend for, there is no effect is given to the transfer inland. You don't have a acquisition of title in the bulk at all. You simply get property outright at the seaport. Say in circumstances where everyone appreciated that the goods would be stored in commingled fashion, and which Quadra would be required to pay 80% of the purchase price, we say that's an unnatural construction of the contract. So that's the construction point, and it's a point that we need in order to acquire a sufficient proprietary interest. But even if we don't acquire that proprietary interest, we say the important point about this additional ground is the identification of the bulk, because the identification of the bulk undermines ground 2 altogether. So, my lords, that's all I wanted to say on ground 2, unless I can be any further assistance to your lordships on ground 2. If I can move then swiftly as I can to ground 3, it's an appeal from the judge's finding that Quadra had an insurable interest deriving from its immediate right to possession, as a matter of Ukrainian law, of the goods that he found to be physically present in the warehouses. And as I've already explained, even if the judge were wrong in so finding, it would not of itself affect the outcome of the appeal. And that's because the judge found that Quadra also had an insurable interest by virtue of having paid for the goods in whole or in part. So unless insurers succeed under ground 2, the latter finding would stand. Now, the judge's findings on immediate right to possession can be seen in the judgment. In the core bundle, it's tab 8, page 132. And the discussion begins at paragraph 87. At paragraph 87, tab 8 of the core bundle, page 132. Discussion begins under the heading alleged insurable interest number 2. Payment of the purchase price was the first one. Now we're dealing with alleged insurable interest number 2, immediate right to possession. And at paragraph 89, the judge recognised that there was an issue in the case as to whether Quadra had an immediate right to possession of the goods vis-a-vis the elevators. And at paragraph 91, and subject to one point which he considered in paragraph 99, to which I'll come, the judge found that Quadra had an immediate right to possession of the Zaplasky cargoes pursuant to terms of the Zaplasky storage agreement and the warehouse receipts issued under it. Although there was no equivalent storage agreement for the Bilgorod and Ismail warehouses, at paragraph 92 of the judgment, the judge acknowledged Quadra's case that it also had an immediate right to possession under the warehouse receipts themselves. The judge noted that on this issue, each side referred to expert evidence of Ukrainian law. And pausing there, the judge recognised, therefore, that there was an issue in the case as to whether Quadra had an immediate right to possession. And for the purpose of resolving that issue, both parties had relied on Ukrainian law expert evidence. Indeed, this is the one aspect of the case to which, as the judge recognised at paragraph 45 of his judgment, page 120, the evidence of the Ukrainian law experts was of significance. The Ukrainian law evidence only went to one issue, as the judge noted at paragraph 45, and he identifies that issue as the immediate right to possession in the subsequent section of his judgment. So going back to page 133 in the judgment, the judge proceeded to address the Ukrainian law expert evidence at paragraphs 93 to 97. And then at paragraph 98, he found that subject to one point, which he considered in paragraph 99 again, Quadra also had an immediate right to possession of the cargoes under the warehouse receipts themselves. Now, the judge's findings at paragraphs 91 and 98 were made subject to that one point in paragraph 99. And in paragraph 99, the judge found that since Quadra had discharged its burden of proving an immediate right to possession under the Zaplasky storage agreement and the warehouse receipts, it was for insurers to prove and had the burden of proving that such right did not exist or was ousted or ineffective by reason of the existence of any competing rights. And he said that insurers had failed to show that as a matter of fact and as a matter of Ukrainian law. In other words, the judge expressly recognized in paragraph 99 that the effect of the existence of other third-party rights upon Quadra's immediate right to possession vis-à-vis the elevators was a matter of Ukrainian law. Now, insurers' challenge to the judge's analysis can be distilled, we think, into four broad points. First, it said against us that Quadra failed to plead as a matter of Ukrainian law that it had immediate right to possession in the cargoes, including where there are maybe competing rights in the cargoes. And as a result, it is said against us that the CMC order did not provide for Ukrainian law evidence on this issue. That's the first point. The second point insurers take, they say that Quadra failed to discharge its burden of proving that it had a right to possession in circumstances where there might have been competing rights to possession. It is said that the judge was wrong to conclude otherwise and wrong to say that insurers bore any burden of proof, evidential or otherwise. Third, it is said that in the absence of any pleaded case of Ukrainian law, English law applies by default. Alternatively, there is a presumption that Ukrainian law is the same as English law. It said that the judge was wrong to approach the matter as one of Ukrainian law. And fourthly and finally, it is said that as a matter of English law, it's not possible for the elevator, the warehouse, the site, to give Quadra a right to possession, which has already been given to someone else. Now, taking those points in turn, as to the first, insurers are wrong to suggest that Quadra failed to plead that it had an immediate right to possession in the cargoes as a matter of Ukrainian law. In response to being put to proof of its insurable interests, in its amended reply, which is in the supplementary bundle at, no, I think it must be in the core bundle, do you forgive me? In the core bundle at tab 16, and if we start, please, first with paragraph 3 on page 244. So this is Quadra's amended reply. Paragraph 3 at page 244. Quadra's pleaded case was that contrary to the case advanced by the defendants, the claimant, Quadra, had an insurable interest and then in the cargoes at all material times as the owner in common of the bulk in the warehouses of which the cargoes formed a part, and or as the party entitled to possession of the cargoes, and or as the party who, having paid sums for the cargoes, would be disadvantaged by their loss. So the three grounds are pleaded there, including party entitled to possession. And paragraphs 4 and following then respond to various subparagraphs of the defence. And at paragraph 7.2 on page 247, Quadra pleaded that by reason of various provisions of Ukrainian law, and for the reasons found by the Odessa Commercial Court, which is based upon Ukrainian law, the warehouse receipts confirmed a contractual relationship between the claimant and Zaplasky, Bilgorod and Ismail warehouses, pursuant to which the warehouses agreed to store cargoes owned by the claimant, which cargoes the warehouses were obliged to deliver up to the claimant. Now that is a clear and positive plea of Quadra's possessory interest as a matter of Ukrainian law. And it was certainly the judge's understanding, as expressed, as we've seen, at paragraph 89 of his judgment, that there was a pleaded issue as to whether Quadra had a right to possession of the goods vis-a-vis the elevator. And he was correct to recognise, as he did in paragraph 92 of his judgment, that the parties had approached this issue as a matter of Ukrainian law. Just to expand on that last point, the only positive case advanced by insurers in the defence in relation to the warehouse receipts was that they had various deficiencies which rendered them invalid or voidable under Ukrainian law. That, no doubt, was a reflection of the fact that the insurer's expert, Mr. Gorbasenko, was of the view that as a matter of Ukrainian law, warehouse receipts were documents of title, and thus in the hands of their holders conferred a right to delivery up of the goods. If the warehouse receipts issued to Quadra were valid, therefore, it followed that they conferred a right of possession upon Quadra. The Ukrainian law evidence as to the validity of the warehouse receipts for which the parties were given permission, in other words, was intimately tied in with and would be determinative of the question whether Quadra had an immediate right to possession of the goods covered by the warehouse receipts as a matter of Ukrainian law. And not only was that the judge's view, it was also the view expressed by Lord Justice Males at the permission hearing, which we can see from Lord Justice Males' judgment in the core bundle, it must be, at tab 12, page 189. That's the start of Lord Justice Males' judgment. The relevant paragraph is paragraph 11 on page 191. But let me just put that into context. Lord Justice Males was required to consider at the permission hearing whether to grant insurers permission to advance what was called the warehouse receipts argument. And permission was refused. But in that context, Lord Justice Males considered and rejected the very same submissions that insurers make before this court. And at paragraph 11, Lord Justice Males makes a number of points, starting from whether the warehouse receipts were effective to grant an immediate right to possession of the goods to the claimant was dealt with at the trial as a matter of Ukrainian law. Permission was granted at the case management conference before the trial for expert evidence to be adduced on the issue of the validity of the warehouse receipts under Ukrainian law, and that evidence was adduced. It was common ground between the experts that the warehouse receipts were documents of title, such as to entitle the holder to call for delivery of goods from the warehouse. Mr. McDonald-Eggers told me that the insurer's own expert gave evidence that the warehouse receipts would grant a right to possession under Ukrainian law. That was the effect of both parties' evidence. It seems to me that the issue, whether there was a right to possession under Ukrainian law as a result of the warehouse receipts, was put in issue on the pleadings. It was certainly the judge's understanding that this was in issue and was a matter to which the parties had dealt with as a matter of Ukrainian law. And he refers then to paragraph 92 of the judgment. So not binding in terms of a decision on the issues for which the insurers had already been given permission to appeal. But the reasoning must apply. It's the very same arguments were raised before Lord Justice Males as are being raised now, and we say Lord Justice Males' decision is obviously right as a matter of pleading and the approach to be taken. And importantly, Lord Justice Males then went on to say at paragraph 13 on page 192 that the so-called warehouse receipts argument does raise issues of Ukrainian law as to the effectiveness of the warehouse receipts to grant an immediate right to possession, which, if it was going to be run, ought to have been raised by insurers at the trial. And similarly, in the context of insurers' application for permission to advance the so-called Bailey wrongful dealing argument, Lord Justice Males, after referring to paragraph 99 of the judgment of Mr. Justice Butcher, paragraph 15, went on over the page at paragraph 17, page 193 of the bundle, to say, in my judgment, regardless of which party bears the burden of proof as to the factual existence or otherwise of other possessory titles, it was for the appellant insurers to raise as an issue what the legal consequence of this would be. In other words, as both the judge in paragraph 99 and Lord Justice Males agreed, the burden was on insurers and not Quadra positively to plead by way of defence that the effect of other third-party rights upon Quadra's immediate right to possession vis-à-vis the elevators, and to do so as a matter of Ukrainian law. In this case, however, insurers advanced no positive case in relation to the warehouse receipts, that as a matter of Ukrainian law, they failed to confer a right to possession in circumstances where third parties had or may have had competing claims to the cargoes. Insurers advanced no positive case that as a matter of Ukrainian law, it was not possible for a warehouseman to give someone a right to possession which had already been given to someone else. And insurers advanced no positive case that there exists as a matter of Ukrainian law an equivalent of the name rule. And in those circumstances, we say it's unsurprising that there was no Ukrainian law evidence as to the effect of third-party rights on the right to possession otherwise conferred upon the holder of a valid warehouse receipt. So that takes me to the second strand of insurers' argument. That is the suggestion that it was incumbent upon Quadra not only to plead, but to prove that its right to possession was not ousted or rendered ineffective by the potential existence of third-party rights. We say it was not incumbent on Quadra to plead the effect of third-party rights as a matter of Ukrainian law. It was not incumbent on Quadra to evidence it either. And again, it's the decision in Dunlop Holdings, to which I referred to earlier, which arises in exactly this context as well. Although the legal burden of proving a possessory right rested upon Quadra, since the effect upon that possessory right of competing third-party claims was not put in issue on the pleadings by the insurers and not evidenced by the insurers, it was not incumbent upon Quadra to come to trial armed with evidence directed to establishing an aspect of the case which had not been put in issue. Having established a possessory right as a matter of Ukrainian law, as the judge found, Quadra is to be taken as having discharged the burden that rested upon it. And in our skeleton argument at paragraph 77.2, we also make a point about the availability of the evidence as to the nature or the possibility, existence of any competing or superior rights is all evidence that was more readily available to insurers. Insurers having had documents not only from Quadra, who's just a trader, but from 11 or 12 other traders out there. Insurers used that evidence that was available to them to construct their capacity analysis, for example, but they did not contend or seek to show that any other trader had a superior right to possession of any one cargo or a right to possess which was otherwise effective to negate the rights conferred upon Quadra. In all, therefore, we say that the judge was correct to find, as he did at paragraph 99 of his judgment, that the evidential burden was on the insurers to establish as a matter of fact and Ukrainian law that Quadra's right to possession was ousted or rendered ineffective by reason of the existence of other third-party rights, and having failed to produce any evidence to rebut Quadra's prima facie case as to its right to possession, the judge was also right to find that Quadra had discharged its burden and established that it had an insurable interest in the cargoes. And that brings me to the third strand of insurer's case, which we address in our appeal skeleton argument at paragraph 74 and following, Core Bundle 5, page 88D. The point is quite simple. We say, having failed to deduce any Ukrainian law evidence as to the legal effect of any competing rights upon the immediate right to possession conferred upon Quadra by the Zaplasky storage agreement and the warehouse receipts, insurers now seek to have that issue determined by way of English law. They haven't got any Ukrainian law to rely upon, so they say, well, let's try English law. It is said first that English law applies by default, relying upon the decision of the Supreme Court in Brownlee. But the rationale for applying English law by default depends upon neither party choosing to advance the case that foreign law is applicable. If either party pleads that foreign law is applicable to an obligation, and that case is well founded, it is the duty of the court to apply the foreign law. And we get that from Brownlee. It's paragraph 116, which is Lord Leggett. In this case, Quadra had pleaded Ukrainian law, and the default rule, therefore, does not apply. Insurers then say that if the default rule does not apply, the presumption of similarity does. This too is wrong. It is wrong for two reasons. First, because it would be procedurally unfair to allow insurers to rely upon the presumption. And secondly, because the presumption is not a fair and reasonable one to make on the facts of this case. I take those 2 points in turn. As to the first, the difficulty in this case only arises because although the court had evidence of Ukrainian law in the form of expert reports served by each party, those reports did not consider the effect of competing third-party rights upon Quadra's right to possession. The reason they did not, however, was because the insurers failed to plead any such case by way of defence. They failed to put the point in issue on the pleadings. And again, in Brownlee, it's Lord Leggett at paragraph 152. He recognised that there are circumstances in which it will be procedurally unfair to allow a party who has advanced a case based upon foreign law and adduced evidence of foreign law in support of that case to invoke the presumption of similarity when that evidence proves inadequate. That was the position in Tamil Nadu, and it is also the position here. Tamil Nadu is in the authorities bundle. It's a decision of Mr. Justice Cook. It's the authorities bundle tab 13, and the relevant paragraphs are paragraphs 99 to 101. And essentially, Mr. Justice Cook makes the very point. In that case, it was a question of Indian law had been pleaded and adduced. It didn't go far enough, and an application was made to adduce additional Indian law. That was refused, and the judge went on to refuse to apply the presumption as well. And so that was because it would be procedurally unfair. So Tamil Nadu was a case in which Indian law had been pleaded and proved, but the claimant had, by its own default, failed to adduce evidence on a point on which it wished to rely. And the judge, Mr. Justice Cook, concluded that it would be procedurally unfair to allow the gap to be filled by applying English law. And we say the same is true here. It is insurers and not Quadra who seek to invoke the presumption, but they seek to do so in circumstances where foreign law has been pleaded and proved. The artificiality of allowing insurers to rely upon the presumption of similarity when the parties have been permitted and have produced expert evidence of Ukrainian law, we say, is obvious. Ukrainian law was pleaded and proved in a manner sufficient to satisfy the trial judge that prima facie Quadra had an immediate right to possession, and if insurers wish to take an additional point, they should have done so by reference to Ukrainian law, and the gap cannot now be filled by applying English law.
Well, it's very odd, isn't it, if they were right? You've got an immediate right to possession as a matter of Ukrainian law, which the judge has decided is the effect of the Ukrainian law evidence, rejecting any suggestion to the contrary by reference to technical points, not appealed, and yet it's now said, oh, well, we can trump all that by saying English law applies because there are competing rights.
Yes, we say that's unsatisfactory.
Well, that's one way of putting it.
Yes.
And the simple point is, you say, if they wanted to run this point, they should have pleaded it as a matter of Ukrainian law.
And then it would have been addressed by the Ukrainian law experts and dealt with accordingly. And they didn't do that. They didn't deduce evidence, and now they have to live with the consequences. And just very briefly, the second point we make in this regard, we say it would not be a fair and reasonable presumption to make anyway in circumstances where although the Ukrainian law evidence didn't address this point, there was nonetheless some evidence of Ukrainian law which looks to be inconsistent with insurers' suggested name of debt equivalent argument. It's a point we make in paragraph 76.3 of our skeleton argument, but I don't think I need to really develop that last point here. Yeah. And so to insurers' point 4 in this context, in the circumstances, we say the fourth aspect of insurer's case here, that is the relevant principles of English law, simply doesn't arise. The judge was right to disregard English law principles and to conclude that Quadra had an immediate right to possession as a matter of Ukrainian law for all the reasons explained. But even if English law had been relevant, then the insurers still failed to establish at trial, as a matter of fact, that the warehouses had previously granted an immediate right to possession of the cargoes to some party other than Quadra. That's the factual point the judge made in paragraph 99 of his judgment. He made 2 points, a factual one, which I've just made, as well as the point about Ukrainian law. And we say it is not open to insurers to contend that there were, in fact, competing third-party interests or insurance claims. And we say that is the effect of Lord Justice Mayall's order upon insurers' application for permission to appeal. The effect of Lord Justice Mayall's order was to preclude insurers from adducing evidence now, as a matter of fact, in circumstances where it had been found not to be proved at trial. So in other words, Mr. Justice Butcher considered whether insurers had established, as a matter of fact, there were competing interests and concluded that they had not. And what Lord Justice Mayall was saying is, in light of that finding, you can argue points about practical consequences in principle, but you don't have permission to try and prove that there were, in fact, competing interests. Because the only point taken by way of appeal, the only point, I should say, insurers had to appeal in this regard related to the burden. They were challenging paragraph 99 of the judgment as to whether the judge was right in terms of the burden, on whom the burden lay. They didn't have permission to come to this court and say the judge should have found, as a matter of fact, there were third-party competing rights, and Lord Justice Mayall was not going to give them that opportunity.
I think Mr. McDonald-Davis' point was that it's not right to say they didn't deduce any evidence in relation to that, because there was the evidence as to the nature of the fraud, that's to say multiple buyers for the same parcel, and the evidence in their conceptual analysis, which is, as I understand it, was by reference to the issue of warehouse receipts being for more quantities than were there, and therefore it necessarily follows that the warehouse receipts were issued to other people in respect of these cargoes. And if the Ukrainian law was, as the judge found it, as to what these warehouse receipts did, it must necessarily follow that there was granted an immediate right to possession to those others to whom warehouse receipts were granted.
Yes,
I think that's his point. What's wrong with that?
No, that's fair. I think that is available to him as an argument on the pleadings. But what that doesn't go to show is that someone had a superior right. That just goes to competing interests, which the judge said in relation to these specific cargoes had not been proved as a matter of fact to his satisfaction. So, Agri-Finance sold goods to Quadra. Line Puzzle sold goods to Quadra. There was no evidence, for example, of Line Puzzle selling goods in situ in any warehouse to any other party. So in terms of establishing whether, for example, someone else had a superior right or a competing right to what were Line Puzzle's goods sold to Quadra, there was simply no evidence. That's the point the judge is making. So it's a question at which level one is approaching it. If you're looking at it at the level of the nature of the fraud, and that overall multiple warehouse receipts were issued for individual physical parcels of grain, yes, absolutely. If you're looking at whether specifically in relation, say, to the first Ismail cargo or the third Ismail cargo, which we looked at, it had been established that there were competing interests to that particular cargo, then the judge said that had not been proved. There was no other evidence of someone having bought a cargo from Line Puzzle. And what can't be established on this appeal is to say, well, there is evidence, or I want to adduce evidence. That's as far as the point goes.
Yeah.
So, my lords, I think that's all I need to say on ground 3, which takes me lastly to ground 4. And by this fourth ground of appeal, the insurers contend that there are important practical consequences of the judge's decision, which indicate, they say, that his decision is wrong, because this is not a case of physical loss, in the sense required by the policy. So not a case of physical loss in a particular sense, in the sense required by the policy. That's what they say. And they identified two practical consequences of apparent concern. First, insurers contend, and this is paragraph 106 of their appeal skeleton, core bundle 4, page 64D, that by his conclusion, the judge has effectively converted the policy from a physical loss policy into one that responds to financial losses. Now, we respond to this point at paragraph 79 of our skeleton argument, core bundle 5, 88G. But the point is quite simple. That unlike Engelhardt, which is in the authorities bundles if we need to look at it, but in Engelhardt, it proceeded on agreed facts that no copper was ever shipped. It's in bundle 6, it's in tab 16 of the authorities bundle. There was a claim under a marine cargo policy for the loss of copper ingots in that case. And as appears from paragraph 1 of the judgment, on page 364, for the purposes of the case, it was assumed that no copper was ever shipped, and the claimant in good faith had paid for and taken up fraudulent shipping documents. Those were the facts. And the discussion begins later on. It's paragraph 39 on page 372. Agreed that the policy covered loss or damage to property. There had to be physical loss of goods, just as there has to be in this case. But on the assumed facts, the court was not prepared to accept that such a physical loss had occurred. And the judge said, on the agreed facts, no copper was ever shipped. In other words, there was never any cargo of copper ingots. Consequently, there was no cargo to be physically lost, or for that matter, damaged. Something must exist to be physically lost. And then a sentence further on, I accept the insurer's submission that the claimant's alleged losses were economic losses due to the acceptance of fraudulent documents in expectation that they covered physical goods, when I might add, they did not. Now, so Engelhardt, therefore, was a case where no goods ever physically existed and where, therefore, there was only ever a financial loss. No copper ingots had been shipped. In this case, by contrast, the judge found that there was grain corresponding to the cargoes that was physically present in the warehouses at the time the warehouse receipts were issued. And so this is not a case of non-existent goods at all. It is instead a case of existing goods. And there's no challenge to the judge's finding that existing goods were lost by misappropriation. And we say that it follows that this is a case of physical and not financial loss. And indeed, insurers themselves acknowledge at paragraph 18 of their appeal skeleton argument, core bundle tab 4, page 44, if there were goods corresponding to the cargoes physically present in the elevators, then Quadra's claim is one for the physical loss of property. So even if others can claim on other policies, the effect of the judge's conclusion is not to convert this claim or this policy into a financial loss policy from a physical loss policy, as the insurers maintain. Quadra has proved the existence of physical goods in which had an insurable interest lost by misappropriation. They have recovered for physical loss, irrespective of what the position may be with other traders under other policies as to which we have no visibility. The second practical consequence alleged by insurers, this is paragraphs 104 and 108 of their appeal skeleton, is that on the judge's findings, insurers might have to pay several indemnities for the full value of one consignment of goods to different insurers. Alternatively, they say Quadra must have to hold the insurance proceeds on trust for all traders who are interested in the same grain. And we address these points at paragraphs 80 to 82 of our skeleton argument, core bundle 5, page 88G. First, we say that at paragraph 80, this is, there was no evidence enabling the judge to assess the prospects of insurers having to pay several indemnities to different insurers, or of Quadra having to hold the insurer's proceeds on trust for other traders. Just no evidence to that effect. So in those circumstances, it cannot be said that the judge was wrong to disregard any such risks and to conclude that Quadra had sustained a physical loss in the sense required by the policy. His exclusive concern was whether Quadra had established a right to indemnity under the terms of the particular policy and having regard to the particular evidence before him. What other insurers might or might not be able to establish under the terms of their policies and on the evidence they might have was not the judge's concern, and rightly so. Secondly, and as we say at paragraph 81, even if the matter is to be approached hypothetically, there can be no principled objection to the payment by insurers of several indemnities, provided that that is the consequence of the cover to which they agreed. Having received the premium from each insured in exchange for the risk they undertook, it is unremarkable that the law should require them to fulfil their respective contractual obligations. And thirdly, we say at paragraph 82 that Quadra's recovery under the policy, as ordered by the judge, reflects its own interest in the goods found to have been lost. It does not reflect, and Quadra is not being indemnified for, any loss that may have been sustained by any third party. And it follows that even if insurers had seen fit to reduce evidence of policies held by competing traders and of those traders' proportionate share of the goods, it's wrong to suggest that each trader's insurance claim should be limited accordingly. There's no, in a sense, over-indemnification, certainly of Quadra in this case. So for all those reasons, we do not accept that the practical consequences of the judge's decision indicate that it is wrong in any respect.
What does the commingling clause in the insurance have to do with this, if anything?
It wasn't a clause that was pushed at trial. I don't think it was dealt in the judgment in any way. It was quoted in the judgment.
I know, but I'm not sure that's quite the question I was asking.
No, I was just starting there to explain why I'm scrabbling around to look for it, my lord.
Okay, sorry. It's at
Where is it?
page 311.
Do you forgive me? I'm getting there.
I asked the question without any agenda, I should add.
No,
I asked it out
of course.
ignorance,
Well,
not with a follow-up.
No,
It says where the subject matter insured hereunder is shipped or stored in such a manner as to be commingled with other property of a like kind, and I'll just skip the words belonging to, but is it on any event it says and or insured by others, which I think is the point, but intended for different consignees, etc. This seems to be a sort of prorating clause. How does it work?
Well, my lord, my honest answer is I'm not sure, not having focused upon it. Perhaps if my lord will indulge me, given the time and that we're due a break round about now anyway, I could take 5 minutes to look at the clause and see if I can make head or tail of it for your lordship.
Yeah, okay, well, we were going to take a break anyway. We'll take 5 minutes now. We do have to finish at 4:15. We can't sit late today.
I'm almost through, so I think there will be time for Mr. McDonald's reply.
Okay, well, we stick to 5 minutes and we'll bang on the door in 5 minutes' time.
Just take it home. So you just set up the day before. Really Smith. That's her. She just want to. That's probably the same. I'm going to
What else you got?
Just fraudulent documents.
You finished ground four here, more or less.
Well,
Pardon.
fraudulent documents is part of ground four, yeah, yes, the addition, so that's. Yeah, yeah. And that won't take long.
I'm very grateful.
No, no, I've been crossing out things as I go along.
That's like it's coming up.
I have to say, Mail was right about 2 days.
Yeah.
I thought by that stage we thought it was 1 day, I think.
We should.
We thought it'd go just at the beginning of the second day, but.
I never thought it was one
I'm not, I
day.
think you'll stay.
I've worked with Peter enough now, so
think
whatever
there's a
he says, I
number-
double
double
it.
My lords, I'm grateful for the break. It's given me an opportunity to remind myself of the commingling clause. As my Lord Justice Snowden said, it looks to be a prorating provision. If the particular facts identified in that clause had been proven established, then it may be one of those clauses which might address some of the practical consequences that my learned friend's talking about in an appropriate case. But it looks looking at property of a like kind belonging to and are insured by others or owned by the assured and intended for different consignees. And so it may be one of those clauses that would provide some protection in some circumstances, but I'm not sure I can do very much justice to the clause.
But it's not relied on. It's never been relied on.
It's not relied upon in this appeal, and I don't think there are any factual findings which would enable them to rely upon it in any event. So, but in terms of, if we're looking at this hypothetically, and looking at it generally, are there provisions which could be included in a policy which would protect insurers from the sort of practical concerns that they've raised? The answer is inevitably yes. This might or might not be an attempt at doing something along those lines, but as a matter of principle, it can be done. And so going forwards, if this is a concern to insurers, they can include it in their policies or something along those lines, wording in their policies which would operate to protect them from the very practical consequences that they've raised.
Presumably it would be for the insurers to query to resist a claim on the basis that these were commingled and the claim ought to be reduced accordingly.
They certainly would have to do so. The point I would make is obviously any changes to the policy would, going forward or even this policy would have to be negotiated, agreed, and the effect worked out. Which let's say it's difficult not having time to fully analyse this and work out exactly in what circumstances it does apply.
Yeah.
But just hypothetically, if the insurers wanted to include a clause which would protect them in this case, they would have to be able to sell that policy with that clause to the market. And the one thing this policy was intended to do is to be extensive. So it may be that if they were to include such a clause, it wouldn't sell and they wouldn't get the business for which they charge premiums. But I think I'm afraid that's the best or perhaps the worst I can do at this case. My lords, that leaves me just with one point, which is the Fraudulent Documents Clause. And I don't rely upon this in a sense as a separate ground. We should win under a separate cover. We've succeeded on misappropriation. That's all we need. The reason we mention the Fraudulent Documents Clause is, again, because it seems to, the application of the clause seems to raise some of the very issues that the insurers say they're concerned about. So this is Quadra's additional ground 3, which we address in our skeleton argument at paragraph 83. The Fraudulent Documents Clause, it's in the policy at page 313, and by that clause, insurers expressly agreed to insure Quadra in respect of the physical loss of goods insured under the policy, through the acceptance by the assured of fraudulent shipping documents, including but not limited to bills of lading and or warehouse receipts. And we say that the clause bites when Quadra is presented with and accepts fraudulent warehouse receipts. And it follows that by this clause, insurers expressly agree to indemnify Quadra where third parties might have competing interests in the goods. And yet, if the clause is to have any meaning at all, physical loss must nonetheless be capable of flowing. In other words, if the goods the subject of the fraudulent warehouse receipts were delivered to a third party with a competing interest, then there would be a sufficient physical loss to Quadra to entitle it to be indemnified under the Fraudulent Documents Clause.
Why don't you just assert, on this footing, on this hypothesis, they're your goods, somebody else has been given a fraudulent document, you just assert your better title against them, don't you? You don't suffer loss.
Well, that's,
I'm not following your scenario.
well, that might be,
Maybe me.
no, it's no doubt me, but there are two paragraphs of the Fraudulent Documents Clause.
Yes.
And the second paragraph certainly is cover physical loss or damage to goods insured caused by the utilisation of legitimate bills of lading or other shipping documents without the authorisation and consent of the assured or their agent. So the legitimate bills of lading, which someone else uses and walks off with our goods. What the first paragraph is doing by contrast is not looking at legitimate bills of lading. The bills of lading or warehouse receipts are fraudulent, and those fraudulent documents have been accepted by Quadra.
Well, no, but the way I read this is that you start with the proposition that it covers physical loss or damage to goods insured hereunder.
Yes.
That must mean your goods.
It must be goods in which we have an insurable interest, yes. Not our goods in terms of we have a proprietary right to them.
Right.
We may have paid for goods in which,
So-
and therefore have an insurable interest by reason of payment, or we may have these fraudulent, well, it does, I don't think it works with fraudulent, we have warehouse receipts which give us a right to possession.
Okay, so then it goes on through the acceptance by the assured or their agents or shippers of fraudulent shipping documents.
Yeah.
Well, let's say, so what the clause envisages is that the assured has accepted fraudulent documents.
Yeah.
And that physical loss must nevertheless be capable of arising. If that's not right, then the clause would be ineffective, it wouldn't cover anything. So we as Quadra are given fraudulent shipping documents, and somehow, nonetheless, despite those being fraudulent, physical loss must be capable of arising. And we say that what this is looking at is where inevitably, because our documents are fraudulent, someone else has a competing interest in the goods. And because that someone else gets to the goods first, that still, for the purpose of this clause, amounts to a physical loss of the goods in which we have an insurable interest for the purposes of that clause. But in it, so the point is, the limited point that we refer to this clause on this appeal was to say it's a clause that envisages that there may be competing interests in the goods, and yet there may still be cover under the policy. That's as far as I go and need to go on this appeal. And the reason I do that is under this ground 4 is because it raises the prospect of there being cover under the policy, despite there being competing interests, which may well raise all of the practical consequences that the insurers have raised. In other words, the existence of this clause itself points to the fact that the practical consequences the insurers raise isn't a reason, as they say, to doubt the sense of the judgment below. That's the argument that we raise on this clause. So unless I can help your lordship, so those are my submissions.
Can I just go back to one of your earlier points, which I may not have fully understood?
Yes.
It's the question of the effect of the contractual terms in the agri-finance contract
Yes.
on the passing of property.
Yes.
If you were right up to that point, 20A has passed property in the
Yes.
divided part, and it's at tab 12. There are 3 points of time, and I just wanted to understand what your case was and what the position was at each point of time. There's the moment or the period in which it's part of a greater bulk in the facility. There then comes a time where, as the contract tells us, the addenda will have identified a period for transferring the goods internally at the warehouse, and it will be separated at the facility in order to be put onto rail trucks to go to the seaport terminal. And then there will be a third point of time at which it arrives at the seaport terminal. And I thought I'd understood, but I may have got this wrong, but your case was that stage 1, when it's in bulk, section 20A says shared ownership in the bulk in accordance with the Act, and the contract has nothing to say about that because the provision that talks about transferring title at the terminal isn't addressed to that kind of ownership in shared bulk. Stage 2, segregation, if I can put it that word, at the facility in order for it to go to the terminal, nothing happens other than ascertainment. Stage 3, title passes in the ascertained segregated parcel once it gets to the seaport terminal. Have I understood correctly that that's your construction of the effect of the contract?
It's not the way we put it. So I'm happy to adopt it, but I think that would perhaps be unfair. The way we looked at it is a two-stage delivery. So there is a stage before we have any interest of the goods, which is the equivalent of my lord stage 1, but we are not involved at that time. The goods are simply in situ in the warehouse. We then get presented with the warehouse receipts, and at that point we pay for them. And it's at that point that we say the analysis my lord has just outlined in relation to his stage 1
It's
apply.
all right. That's what I was treating as stage 1. You've got your warehouse receipt, and they're part of an undivided bulk.
Yes, okay.
That is my stage 1.
Well, then it's my mistake. Yeah, at the point. Yeah. So in my lord's stage 1, we get the warehouse receipt. We get an invoice with that, and we're asked to pay for 80% of the purchase price, and we do so. And at that point, that's the point that we acquire our insurable interest. And it's at that point, that is what the transfer at inland warehouse is referring to, we say. There isn't that intermediate stage. My lord has in mind that the transfer at inland warehouse refers to the dispatch from the warehouse after the storage. So our stage,
I see.
there are only 2 stages,
I understand that.
not 3. The first stage is
Is there
when we pay, get our insurable interest, and there is some form of transfer at inland warehouse. And the question is, what is that transfer inland warehouse? We say that is the transfer of title in the undivided bulk inland.
I understand that. Thank you.
Okay. Thank you. Anything else?
So sorry, I'm not sure I follow the answer now. When the ascertained goods are on the trucks, where's title to them, going between the facility and the port?
Well, that's a gap, and that's why I can understand why
Yeah, well,
my lord.
That's what I thought
yeah,
the question was
that's the
actually
point.
aimed
That's the
at.
point that troubled us,
Well,
because it seemed to us on this construction. I mean, you may be right. It may just be a gap in the protection, but it didn't seem to us that on this hypothesis, the property and the goods was retained when they were on the trucks.
well, I mean, that would of course be an uncomfortable position for my clients, but it may be a gap. But certainly in terms of when you look at the contract and you're construing the English law contract.
Well, actually, it wouldn't matter for your clients in this case, would it? As such, because you're not claiming for the loss of goods which were lost in transit from the warehouse to the port. So the point doesn't arise other than as of testing the hypothesis. You're claiming for the loss of goods from the bulk.
In my state,
And in terms of
precisely
the
right.
insurance, it wouldn't make any difference because you'd clearly have once the goods are ascertained, you've got an immediate right of possession in any event.
Yes.
If they're, as it were, stolen en route or damaged en route. So it wouldn't, the fact that you didn't have propriety interests anymore wouldn't affect the insurance.
That's right. And my Lord Justice Snowden is right. It doesn't arise on the facts of this case. The reason I said it would be a concern to my clients, because of course, their principal concern is by handing over 80% of the purchase price, they wanted property in an undivided bulk in the warehouse until it was delivered to them. When it's delivered to them at the seaport, according to the contract, they get
But
the whole title.
The problem
Is the gap.
being is that there isn't a bulk, that there isn't a sort of undivided bulk of which they
On
are
trucks.
tenants in common when the stuff's put onto trucks.
Yes.
It's
And
no longer the bulk which they own in common. It's
and that might be the gap that they haven't anticipated in the contract, that there is a period of time
Right.
between being released from the warehouse. And we get an indication of the sort of time frame from the physical delivery of the 800 metric tons. It was released from the warehouse on the 14th of January 2019. It was delivered at the seaport on the 17th of January 2019.
yeah, well,
And then maybe there's that gap in 3 days, and it could be lost in those 3 days. But
yeah,
they would have
moving it from the safe storage to a container for shipping is on rail trucks is probably high risk enterprise in the general scheme of things. But anyway, it doesn't matter for the insurance. No, okay, all right.
Thank you.
Anyway,
Thank you.
interesting though it is. Thank you.
Subject to that, thank you very much, Mr. Kershaw.
Thank you.
Yes,
My lords, I'll be as economic and as quick as I can. Obviously, just to repeat, our case on the first ground is not that no goods existed. Our case is there's no evidence or satisfactory evidence that the goods corresponding to those described in the warehouse receipts existed, and I'll come back to that. My learned friend referred to the capacity analyses, and of course the analysis itself is not in the bundle, but the submissions based on the analysis is in the core bundle, sorry, the supplementary bundle, tab 4. And I raise this because of a number of submissions my learned friend made. Sorry, I said tab 4. It's a supplementary, I'm so sorry, it's a supplementary tab 4, not core. So this is the schedule, so I should make this clear. This document is not evidence, it's submission based on evidence. And the evidence itself, which is relied upon to create this capacity analysis, is at, sorry. Yes, paragraph 6 on page 100. And all this was intending to do was to look at the commodities in general terms, barley, corn, wheat, and others, by reference to the capacity of each of the facilities, and asking if, and then looking at the documents referred to in paragraph 6, which are warehouse receipts, inspection reports, monthly declarations to insurers, decisions of the Ukrainian courts, and other miscellaneous documents relating to the fraud. And this is because the insurers had access to these documents. And all it was trying to do is work out, well, if the warehouse receipts were saying this much is coming into the facility, not just for Quadra, but for all traders which were available to us, and other commodities were leaving, at what point in time were the warehouse receipts saying, we hold these goods, or goods are coming into the facility when there was just no more capacity? But it wasn't actually saying by reference to the type of the commodity, it was just looking in general terms, barley, corn, wheat. Now the reason this is important is because it was said that by looking at the burden of proof and the decision in Dunlop, that the burden shifted because we had, as insurers, some privileged access to information which would allow us to bear that burden. And that was one of the, if you look at the decision in Dunlop, that's one of the considerations which the judge had in mind, which of the parties, if not both, had access to the information in order to bear this particular burden on an evidential basis. And our case was that when it came to the fraud or the operation of the fraud, we had no privileged access. And that's because whilst we may have information about the quantities going in and out, but we had nothing as to how the fraud was operated. And this was recognized by Mr. Justice Butcher because there was a claim made by Quadra for damages for the implied term for the claim wouldn't be paid late.
Section 13A.
Correct, and that was dismissed. And one of the considerations which the judge took into account is the fact that this information wasn't available to the insurers because a lot of documentation, a lot of evidence had been destroyed. Yeah. And so insofar as my learned friend is relying upon this capacity analysis in order to assist his arguments on burden of proof, we say that's not available to him. And in fact, we say, and that's paragraph 142 of Mr. Justice Butcher's judgment. But in paragraph 58, subparagraph 1 of our skeleton, appeal skeleton, we would say why Quadra was actually in a better position to get access to this information, not least because they operated in Ukraine, whereas the insurers were not. Then the next point I want to address is the evidence of the Mr. and Mrs. Gonchar, the inspectors, which are summarized in paragraph 47 of the judgment of Mr. Justice Butcher. And I said before, and I'll say it again, I rely upon the evidence which was given, which I regard as a fair summary of that evidence. What we do challenge is the ability of the inspectors to attest to issues of identity by reference to crop year or by grade. Of course, we'd accept that they can recognise barley, corn or wheat in general terms. And when it came to quantity, Mr. Justice Butcher's finding was based on the evidence, was that all that the inspector did was to look at the surface and couldn't see underneath. Now, I understand his comment about the laser meter, but what we do challenge the ability of the inspectors to assess quantity in these of the described goods. And we say in those circumstances, the limitations identified in the inspections set out in Mr. Justice Butcher's judgment are correct, but he failed really to take into account what that meant in these particular circumstances.
If the tank is full to the 75% mark, the only basis for concluding that it didn't in fact include 75% of its maximum volume would be as if it had a false bottom or some other packing material underneath.
It could be, my lord, that it was well, it's a combination of things. It depends how that depth was judged. But secondly, if you say 20,000 tons of grade 3 corn or grade 6 corn, he couldn't say. He just couldn't say.
No.
He might be able to say there was 20,000 tons of grade 3 corn if it was in fact grade 3 corn, but we don't know if it was grade 3 or grade 6 corn. And so you have to look at all these facets: quality, quantity, description, etc., holistically, to use a favourite phrase, and you ask yourself, were they in a position as inspectors to attest to the quantity of the goods, having regard to those factors? And I think my learned friend said, well, when it comes to the nature of the fraud, which was that there were several warehouse receipts issued for the same goods, for the same consignment, what we would say, of course, is that that may refer to the same type of, what the descriptions of may refer to the same types of goods, but it doesn't necessarily drill down into the details such as the grade or the crop year. Similarly, it may well be that a warehouse receipt was issued for the first consignment when it was there, but by the time the sixth warehouse receipt was issued, the first warehouse receipt holder took the goods and there was nothing left to deal with. So in those circumstances, one can't assume that the goods corresponding to the warehouse receipt were there. Then we come, my lords, I think to a point which I'm not sure was discussed in the same way as being here below, and I'm not sure it actually features in the party's skeletons, which is the issue and the role of the declarations to the open cover. And for this purpose, it's worth looking at the core bundle, tab 19, page 320. And all I'm asking is to bear in mind the nature of this policy. So page 320 has the declarations provision.
Yep.
And it refers to the coverage of these goods as declared. But what should be understood is, as far as the insurers are concerned, it's not obligatory. Now, what that means is they can't say no to the coverage. So when there is going to be a declaration of goods of this nature, they have to get the description right. Now, my learned friend says, well, the description refers to 5,000 tons of corn held as the Pulaski, entering a particular day. But it does include a reference to the contract. Now, whether or not that was understood by the underwriters in terms of what they actually meant, doesn't matter.
They didn't have the contracts though.
But it doesn't matter because
There's evidence that they had the contract.
But it doesn't matter because they're not exercising any underwriting judgment because they're bound to accept any declarations. But because it's obligatory as far as the insurers are concerned. But what does matter
But the question of whether there's an insurable interest is defined, amongst other things, by the terms of the insurance. And the point that was made against you is, look at the terms of the insurance. The insurers couldn't have cared less, putting it colloquially, whether this was grade 3 corn or grade 6 corn, what year, what was. They never asked any of that for any of that information as part of what they were told.
Because they're not obliged to, they're not entitled to it, because they're obliged to accept the declarations. They exercise no underwriting judgment. But what's important for this purpose is not what the insurers might or might not have been interested in, because it's not part of their underwriting process. Because the underwriting took place when the open cover was agreed. What matters is what the insureds intended to declare. That's what matters. And you can identify what they intended to declare, not just by the description of the commodity, the quantity and its location, but by reference to the contract number. Because the contract number then goes on to describe the additional specifications, such as the crop year and the grade. So it's not an answer, I would suggest, and it wasn't an issue which was debated.
Isn't that just what, by the contract note, that's what they've agreed with the seller that they will receive and are entitled to receive? It's not quite the same thing as saying, as between insured and insurer, this is what I want you to insure.
Well, as I said, and forgive me if I'm repeating this, I might repeat from my earlier submissions, but what the claim for an indemnity is based on the loss of the goods referred to in the warehouse receipt. And there's no way one can walk around that. And so just assume the goods were actually grade 6 and not grade 3, just for whatever reason, the wrong goods were delivered. That's not the claim being made. The claim is of the loss of the goods referred to in the warehouse receipt. And if one goes to the declaration and looks at the contract, it's goods of grade 3. It's not goods of grade 6. So, my lords, my only point I want to make is, it's not incumbent on insurers to ask for further information or to be interested in information. That's not the role of this sort of cover. But what is indicative is the intention, firstly, of the insured by declaring the cargo. And for that purpose, one needs to look at the contract reference, because that will tell you what the contract is. But secondly, the claim being made itself.
And did you also say, I think, that it does feed into the declaration, because whether grain is for human consumption or for animal consumption, let's say, which will be a function of its grade,
Correct.
Will make a considerable difference to its value, and the premium is calculated by reference to value. So that if it were declared as for animal consumption.
Correct. Well, and to be fair, to give you credit, my learned junior made the very same point to me earlier today, and I'll obviously capitalise on it.
It must be right.
It must be right. But the point I want to make is that when it comes to Ismail, for example, two of the Ismail cargoes, one is for feed wheat and one is for ordinary wheat. And of course they do, therefore, different specifications, different values. And of course the values are also specified.
Yeah. Okay.
And then, my lord, forgive me, I know I'm telling you something you already know, but I'll just in case. The absence of an insurable interest does not necessarily make the contract a wagering contract. And
I knew you'd pick up on that one. You don't need to expand. It's a long time ago, Mr. McDonald, but I was Councillor in Fiji, so
I know, my lord, and other cases too. Now, when it comes to Inglis and Stock, just very briefly, there's no evidence, no indication in the judgment as to what the other cargo was. So general trading ship, there's no evidence as to what the other cargo was. What we do know is we're talking about 3,900 bags or 390 tons of sugar, and the issue troubling the court is how the two parcels making up that 390 tons, not anything else. And what is striking, there was a reference in the judgment to the bills of lading, which had marks as to the saccharin content, which were cross-referred to labels on the parcels themselves with the same saccharin content. So there were by the page, I think it was page 102, there is reference to these bills of lading containing the same marks which are on the bags of sugar, the bags of sugar themselves. So that, if anything, there really was an identification of the bags in that case. Devaney and sorry, I can't remember the second name. Devaney and the decision of the divisional court in Devaney, where Kenya, sorry, of course. Mr. Justice Leggett and Sir Richard Akins were sitting in divisional court, and they were considering notions of title and possessory interest to undivided bulks. And what I would suggest from paragraphs 23 and 57 of their judgments, it is plain that they were equating the treatment of title, which is dealt with by statute, and the treatment of possessory interest, which is not dealt with by statute, by reference to the same concept of bulk. And that, of course, is one of the factors I take into account in my submission as to what constitutes an identification of goods for the purposes of an insurable interest. I think at one point my learned friend said, and forgive me if this seems like a scattergun approach, but it's just a series of points which I've noted down. It was somehow incumbent on insurers to identify an authority which supports our position. What we say, of course, is that this is a point which is absent authority, and therefore it's really a matter for this court. I mean, the only authority is that the decision of Mr. Justice Butcher.
Well, there's no English authority directly on point, and it's an issue of principle which this court has to decide.
Correct.
Which is no doubt why the judge gave permission to appeal.
Correct. The Section 20A, there are a number of factors there, and I know I addressed my lords on this yesterday, but there are a number of requirements for the bulk to be identified. And of course, the first is there has to be a mass or a collection of goods. And that's part of the definition. And the other aspect is the mass or collection of goods has to be within a defined area or space, which the judge recognized conceptually could be quite broad. And the third aspect is that the goods within, whether you refer to it the goods in the bulk or the goods in the defined space doesn't matter, because it leads you to the same conclusion, have to be interchangeable with any other goods in that space.
No, it does matter. Do they have to be interchangeable with the other parts of the bulk in the space, or with everything in the space? That's a fundamental difference.
Well, I say it has to be other parts of the bulk, and for what? I mean, for just, and it's the same approach to English and stock, and it's also the same approach in the commingling clause. And I'm not relying upon the commingling clause, but you can see in the commingling clause one of the issues there is to identify the commingling of goods of like kind.
So your submission is it has to be capable of commingling with everything else that forms the bulk, even if there are other things within the space in which the bulk is contained.
No, so it's not permissible to be able to be commingled with
anything else in the space.
Anything other than like goods of the like kind.
And if there's anything in the defined area or space which falls into that category, that prevents
that defined area
Section
space.
20A applied. Yes, that's what I thought was your submission.
So your submission yesterday was that, because we asked you specifically, that you wouldn't fall within 20A if you had two bulks, as it were, one of corn and one of wheat, in the same defined area.
Correct. It's got to be.
That's your case.
Yeah, exactly. So
then you are submitting that the commingling that matters is commingling with what else is in the space, not commingling with what else is in the bulk.
Well, I say, I think you may disagree with me, but I'll say it. I think the bulk and the space are the same thing, because the bulk is defined by reference to the space. So a bulk is goods within a defined space, and which are interchangeable with any other goods in that. You say bulk, I say space, but I think because bulk is defined by reference to space, it's the same result. Now, I understand, my lord, if you disagree with that, but that's my submission. And I'm not relying on the commingling clause, it's just an interesting.
Because it says is such that any goods in the bulk are interchangeable with any other goods therein, the same number or quantity. So it's clearly defined by reference to the bulk.
Yes, but I say the bulk is defined to mean goods within a defined space.
You say there can't be a different bulk
Correct.
from everything that's in a particular space.
And the classic instance, of course, is you've got an oil tank or a silo of wheat or whatever it might be. That's what everyone understands as an identified bulk. My lords, I want to go on to the other question of title, which I don't think I addressed you on, which is this point which we were discussing with my learned friend just before he finished, just after the break, which was about this reference in the, and it was probably worth looking at the contract itself, which is tab 12 of the supplementary document. And the first point we'd make is that page 205, which contains the relevant provisions, before one gets to price and payment, the last paragraph before that deals with the title of ownership. Now that's, my lord, dealing without any exception, without any reservation, without any qualification, when title to the goods passes. If it were intended to have a two-speed or two-stage transfer of title, you would expect it to be dealt with there, and it's not. And so my learned friend relies upon the phrase which comes after the word payment, which is the period of transferring goods at internal warehouses from seller to buyer. And that's not expressed in terms of title. Now, it could be transfer in terms of what's held for the account of someone, that's what, or for other purpose, in administrative purposes, whatever that may be, but it's not dealing with title. It doesn't say it is. If it was obvious to the parties that actually there should be a transfer of title in an undivided bulk first, followed by an absolute transfer of title, firstly, one wonders whether you actually need that, because the whole concept of having transfer of title in undivided bulk is once it's appropriated or segregated, the title will automatically transfer. But if that were the two-stage approach envisaged, then you would have thought it would be actually spelled out in the contract, but it's not.
So what's the transfer that's being referred to?
Well, I said it could be a transfer of possession, it could be a transfer of the account of, it could be any. It's not explained in the evidence, we just don't know. But it's not referring to title as such. So that's the one thing I would say is clear. And it's also consistent with the provision on the previous page, the 204, which is, you can see about halfway down, obviously on the English side, you can see the paragraph, the seller shall have the right to dispatch the commodity is not covered by the pledge certificate from other grain warehouses in respect of this contract. So if there's no pledge certificate, then there's still an opportunity for the seller to dispatch the goods from other warehouses. So what I would say is, for whatever reason, this is not dealing with title. And if it were, you would expect it to be dealt with in the title provision, but it's just, there's no reference made.
The transfer, you say, is that since this stage is said to be the moment of issuing the warehouse receipt, the transfer is essentially from what was Mr. Kershid's stage one, i.e. the goods have got nothing to do with the buyer, they're just in the warehouse already, to stage two, which is they are recognised as part of a bulk. I say that in a neutral term,
yes,
but part of a bulk which has been assigned to this particular buyer with whatever consequences.
So they may be changed. They may be changed.
And they may be changed, but that's there is a transfer in the sense that they've been allocated.
But it doesn't mean
they've been allocated to this buyer, to use a neutral expression.
Correct. But it doesn't, what I say is that the intention was not to transfer title.
I understand.
There was a, look, I've made the point already, and I'm sorry, I know it's 1 minute over, I've just got 2 more minutes if that's all right.
Yeah.
I made the point yesterday, just in case my learned friend referred to it, I repeat it. I know you've heard it, which is the mere fact that the insurers have taken premium by reference to a declaration made under an obligatory cover doesn't mean that that's not I would say it's not a relevant consideration because premium is returnable in the absence of an insurable interest.
Yeah.
My lords, I think that's all I've got. And I would therefore ask for the appeal to be allowed on the reasons I've given my submissions.
Well, it won't surprise you to hear that we're not going to deliver judgment this afternoon. We will reserve our judgment. No promises as to when you'll get it, but we'll do our best to get it to you as soon as possible. In the usual way, you'll get it in draft with the embargo on top of it. The Master of the Rolls is very keen. We emphasise the terms of the embargo and the importance of recognising that it is only to be used for the specific purposes referred to in it, and anything else would potentially be a contempt of court. You should provide corrections rather than inviting us to reconsider points or rewrite our judgment. And if you can agree a formal order so far as possible, if you can't, we'll deal with any submissions in writing. Only 2 remaining points. One is just a practical point. Various stages of the London wine storage case has been referred to. Lord Justice Snowden, who has a clearer recollection of it than I do, says it's only reported very oddly in Palmer's company cases. It's extremely difficult to get hold of. Those, maybe your junior has already done it. That would be incredibly helpful. I was about to ask for it.
Unfortunately, they're hole punch but loose. Is that?
Don't worry, just pass it up. Be absolutely fine.
If they need it in a different format.
There's a 3.
I think there's 4 now.
1, 3, I think. Can I give it to you after? Sorry, if I could hand that up, please. It's in Palmer's company cases.
It is Palmer's company's case, which is ECC.
One
Yeah.
more team on here.
Thank you very much.
That's clean as well.
I should add, I haven't actually had a chance to review it yet, so.
No, don't worry. I mean, this is really so we've got it for ourselves. It's very helpful. Thank you very much. Thank you. Thank you for that. And it only remains to thank all parties for their. Oh yes, sorry, there was one other thing. Could you please ensure that we get the transcripts of today and yesterday?
Have you not received yesterday?
I haven't received anything. Hadn't received anything as of this morning. But if it's possible to provide transcripts in hard copy and electronically, that would be very helpful.
We'll make sure that happens.
And the third thing was, as Lord Justice Popplewell reminds me, could we please have the capacity analysis?
The actual document. Very good.
And it only remains to thank all parties for what has been an extremely impressive series of submissions which raised some extremely interesting and difficult points which we will need to go away and think about, and those thanks extend not just to you and your juniors but to those behind you as well. We know how much hard work goes into preparation of these appeals.
Thank you, and I think I'm sure, I'm thanking you on my own behalf, also on behalf of my learned friends for sitting early this morning. It's very grateful.
Right.
Oh, yes, my learned junior just reminds me that the capacity analysis is an Excel spreadsheet. Would you like that electronically?
Yes, please. Yes, please. Yes. Okay. Thank you very much.